Welcome to the Rob Call Bottom Up Show, sponsored by opednews.com, available on Pacifica Radio, Progressive Radio Networks, iTunes, Stitcher, SoundCloud, and more. My guest for this show is attorney Paul Hetznecker. He maintains a private practice in the Philadelphia area, focusing on criminal defense and civil rights. He's represented thousands of clients facing all kinds of charges from major felonies, complex drug conspiracies, racketeering offenses, white-collar crimes to capital murder. In addition, he does volunteer work as well for civil rights, and he's represented people, and not just volunteer work, but other work as well, with people with claims ranging from police misconduct, including wrongful death, as well as prisoner rights, sexual harassment, and racial discrimination claims. He's also an instructor at Arcadia University, and his website is pauljhetznecker.com. And I'll repeat that again later. I should spell it, though. pauljhetznecker.com. Welcome to the show, Paul. Good to have you back.
Thank you, Rob. It's a pleasure to be back.
Yeah, the last time was fun. We had you on with Noam Chomsky. That was a treat.
Yeah, that was many years ago, and it was on, I think, the celebration of Martin Luther King's birthday, and it was quite a treat. I felt honored to be on with Noam Chomsky at the time, and you as well.
So you're doing, as usual, amazing work, and I'm constantly dazzled by what you give to the community of activists. So tell us a little bit about what's on your mind, and I just wanted to have a kind of a broad-ranging conversation with you. You're a great example of the kind of attorney who gives to the justice community, who gives back. So what have you been up to lately?
Well, first of all, I'm very honored by your comments, Rob. I appreciate the opportunity to represent individuals charged with criminal offenses, and also vindicating those people whose civil rights have been violated. So I feel very, very honored to do what I do. I've been up to a number of things. I've continued this quest to expose police corruption here in Philadelphia. I've filed a number of pretty significant major lawsuits involving police misconduct, from wrongful death to a case where homicide detectives coerced a statement from a defendant who was eventually acquitted. And then I brought the civil rights case against the officers, the homicide detectives. So I've been doing, the kind of work that I've done all along. I'm really, really excited about the prospect of the resistance that has developed in this country over Trump and over the consolidation of corporate power in this country. And I feel very encouraged by the extent to which people are starting to understand that real reform in the criminal justice system is tied directly to the quest for social justice. And I think for a long time, those who were involved in the criminal justice system, whether as advocates or those who were victims of the criminal justice system and its injustices, were marginalized in the conversation over the quest and the struggle for our democracy. And I think now there's a much more enlightened dialogue and discussion regarding the importance of those protections guaranteed under the Fourth Amendment and the First Amendment, and those protections provided within the framework of the criminal justice procedural rights that are provided in the criminal justice system. So I'm really encouraged by the exciting development that has happened over the course of the last few years, and the enlightened discussion. So and the real reform that's taken place.
Now you're talking about protests.
I'm talking about protests, but also across the board. The sense that we have, those of us in the criminal justice system have battled, and this is now starting my 32nd year being an attorney. But even before I went to law school, there was a real kind of ignorance about the extent to which the criminal justice system was politicized and political in its nature. The war on crime morphed into the war on drugs, morphed into the war on terror. They're all the same war. It's a war on our civil liberties and our civilian populations. And it's a quest for expansive police power against the bulwarks that are guaranteed under the Constitution. So a lot of what I see as the real kind of revelation of the politics of the criminal justice system have resulted in some real reform. And I think that's an important step. And that's only occurred within the last 8 or 9 years.
What kind of reform?
What, I'm sorry?
What kind of reform?
Well, talk of reform, let's put it that way. Talk of reform and real efforts. For example, getting rid of mandatory minimums. The mandatory minimum structure, which was a way in which stripped the judges of discretion and empowered prosecutors, whether it's federal prosecutors or state prosecutors, to control and determine the outcome of so many cases in the plea bargaining process. You know, unfortunately, in this country, most cases don't go to trial. So the full panoply of criminal justice rights that exist under the criminal justice system in this ongoing social contract with the state, once you're charged, they're not exercised for the most part because of the draconian sentences, the mandatory minimums, the guideline sentences that guarantee lengthy periods of incarceration for those individuals charged with crimes. So in the process of negotiating away many of these rights in exchange for a lesser sentence, we don't have the same kind of challenges to the system that need to happen, to the credibility of police officers at a preliminary hearing, to the lack of disclosure by prosecutors of Brady information, critical information that needs to come to the fore and be revealed in order to guarantee justice. And without the exercise of those panoply of criminal justice rights, of criminal procedural rights, the assembly line of injustice, as I call it, is pervasive. And I think real reform has been an examination of the need, the necessity of having the challenges available under those, or the guaranteed by those rights, the right to cross-examine witnesses at a preliminary hearing, the right to have a preliminary hearing, the right to proceed with a motion to suppress and not worry about being discounted or being or losing the prospect of a fair negotiated plea after the motion is litigated, in order to ferret out police misconduct, in order to ferret out unconstitutional practices. I mean, these are really critical stages in our, not only our criminal justice system for those charged with crimes, but also for our democracy. Because the point at which our liberty interests intersect with the power of the state, that's the criminal justice system. And every right that's undermined and every right that's reinforced in the criminal justice system is a right that applies to each and every one of us in our democracy. So I see reforms happening, albeit in small measure in my mind, because there needs to be real radical reform. But I'm at least encouraged by the dialogue and the fact that we don't have mandatory minimums as a priority. We don't have mandatory guideline sentences as a priority anymore.
Now, has that just changed recently?
It's changed within the last 5 or 6 years. It's been a long battle. Rob, it's been a battle over decades. You know, we felt as criminal defense attorneys frequently like we were voices in the wilderness, you know, and the clarion call for freedom and justice wasn't our voice that was heard. It wasn't hearkened to the real inhumanity and the real human rights violations that existed or still exist in our criminal justice system. So
now there was just a new legislation passed in Congress regarding criminal justice. That
the First Step Act. Well, it has an effect, but it doesn't go far enough. I mean, and this is part of the problem. It's always this struggle between reform and revolution, in the sense that, you know, there needs to be a real radical change in the way we perceive how people are charged with crime, who is charged with crime, challenging the racist and class-based system of our criminal justice system and the roots of it. There needs always to be a careful examination of the historical roots and making them relevant to the existing cases that we now face. And that's a real important task. But I think every time there's a movement of some reform, it enhances the prospect for a more radical change later on. And it's like any change, as we know over the years, we want radical social and political and economic change. But wanting it and achieving it are two different things. And the reforms that we can take that do offer some measure of accountability to the power of the state, do offer some measure and alleviate some of the pressures and some of the injustices that have existed, we'll accept those. And we have to. As criminal defense attorneys and civil rights lawyers, we take those and we take them as small victories. But this is part of chipping away at the rock. I mean, I tell young lawyers all the time, you can be faced with tremendous odds, and you may not win every time, but you got to continue to chip away at the rock. Always chip away at the rock of injustice, because with each chip, with each small measure of justice that you get for an individual client, or for a group of clients, or for a family, that is immeasurable for that individual and that family. And that, to me, is so significant, and it transformed me at an early age, from being someone who was thinking just about the big picture and not the small individual struggles that exist every day for people, both politically and economically and socially.
So, I call the show the Bottom Up Show, and really that's what you're talking about. You're talking about bottom up justice, one case at a time, really.
Exactly. It's precisely it. And I think, one of the things that I often say to the young people that either want to be lawyers, progressive lawyers, radical lawyers, or clients that are social activists, I'll say to them, with age and wisdom comes the recognition that change over a lifetime, the arc of change over a lifetime, takes many different forms. And when you're 19 and 20 and you want social justice now and immediate, we should never try to harness that in a way that undermines it. But what we should do when we're 29 and 30 and 39 and 49, and now I'm almost 59, we want to make sure that we measure the sense of injustice against the battle for justice over the arc of a lifetime, over many decades, because it's a constant struggle. The civil rights movement, as you well know, Rob, and you've been a perfect example of hearkening this battle cry. Civil rights movement didn't end in 1960. It didn't end with the significant legislative measures that were enacted in order to right the historical wrongs that had existed in our racist society for so long. It's an everyday struggle. It's an everyday battle. And so the quest for social justice, as you say, it can be measured in those small increments and those small stories, because for the individual, it's not small at all. It's monumental.
Now, you've been involved in some real battles too. And I'm curious, you've represented thousands of people, some of them pro bono. What have been some of the cases that for you felt made the biggest difference, that gave you the most gratification, the most joy?
That's a great question. Boy. Well, I can think of a few. And I can certainly the cases we won in 2000, during the 2000 Republican National Convention, when they arrested over 400 people here in Philadelphia, right before the coronation of George Bush as the Republican nominee. They undermined the constitutional rights of hundreds and hundreds of individuals who came here to protest. And we won as a group of lawyers. And I fortunately, had the great honor of being one of the lead attorneys. We won probably over 90% of our cases, maybe 95% of those cases. So that was a tremendous sense of gratification. During the Occupy movement, we had 4 major mass arrests. When I say mass, multiple defendants, I'm not talking about hundreds, but we had 4 major large events in which people were arrested, 4 major cases. We won every single one of them. And again, I had the great fortune of being one of the lead attorneys in each one of those cases. So I had this great sense of gratification in representing those individuals. I had a case where I represented death penalty abolitionists. This is back in the late 90s. And they were charged with obstruction of justice outside the courthouse in Philadelphia because they had been opposing the death penalty, generally, and not specifically as to any one case, and they were charged with obstruction of justice. And on the first round, I lost. I represented all 7. But on the second round, in a reconsideration, I won, and they were all acquitted. And so that was also a very significant moment in my life, in terms of, it was kind of the To Kill a Mockingbird moment, in the sense that I felt like, having lost it the first round, I came back and was able to prevail for them in the second round. So, those were the things that stick out. But I think probably more than any of that was saving individuals who were charged with the death penalty, whether it was through negotiation or whether it was through a verdict at trial that prevented a first-degree verdict, and they got some lesser charge when faced with the death penalty, or, arguing in front of a jury to save a man's life. So those were also very significant moments in my career.
That's awesome. Now, you mentioned that a lot of decisions are made with plea bargaining rather than going to trial. Is there what percent goes to plea bargaining? How many go to trial?
Over 90% are plea bargaining in this country, and probably upwards of 95%. It depends upon the jurisdiction. You know, the great mythology in our society about the criminal justice system is that there is a full panoply of rights that is exercised in every case, and that just isn't the prospect, and it isn't the process. We have an assembly line of injustice in this country, and it's been predicated on mass incarceration. It's been predicated on expanding the prison industrial complex. It's been predicated on racist and class-based policies that have existed from the time this country was conceived. So, you know, the battle over, you know, what becomes a measure of justice in a system that by its very nature encourages the plea bargaining process is difficult. It's a very difficult struggle.
Now, you, in doing some of these pro bono representation cases, like the one with the 2000 Republican convention, you worked with the current DA of Philadelphia, right?
I did, yes. In fact, Larry Krasner and I started in the public defender's office together in 1987, and we became ideologically aligned. We were already aligned, and so we, over the course of almost 2 decades, we represented both together and separately hundreds and hundreds of protesters. But yes, he and I were the 2 key principal lawyers, among others, and I don't want to discount anyone else, but during the Republican National Convention, and then those arrests and the defense of those cases, and then again during the Occupy Philly movement and those arrests. So we both coordinated the representation in both cases.
And that his election as the Philadelphia DA really shocked a lot of people, I think, and is really changing things. Now, I recently interviewed Patricia Cummings, who he brought in to manage the integrity department of the DA's
right.
office. And she has made it public that one of the biggest challenges she faces is the police. Yes. And you mentioned police corruption. And yes. So talk a little bit about that. You've dealt with and you've stood up to them, and I think you've helped to get them to change some of their policies too.
Well, it began a long time ago. It began when I was a public defender, a young public defender going to the police districts where the preliminary hearings were held, and seeing the level of corruption and perjury that existed in the cases that I handled, and feeling a sense of great outrage and wanting to address those cases in some significant fashion. I took on several investigations on my own while I was in the public defender's office, investigating cops that were corrupt, that were conducting corrupt practices in drug arrests and other arrests as well. And so I took it upon myself to fight the corruption while I was still a public defender. And then, of course, after I left the public defender's office in 1993, I continued that with the civil rights cases I had and also the criminal cases that I continue to represent individuals in. So yeah, corruption, it's been cyclical. And one of the things that I said to City Council almost 9 or 10 years ago as a representative of the National Lawyers Guild on police corruption is that it's cyclical. And unfortunately, we've had a crisis management mode in the police department. There has been no real whole-scale challenge to the entrenched culture within the police department, a culture that has existed in Philadelphia and many other jurisdictions as well for decades. And it's reinforced over and over again. There will be this notion of a few bad apples getting indicted and being prosecuted or being removed from the police department doesn't address the underlying systematic corruption within the police department that has existed for decades. And now I'm sorry, Rob, go ahead.
My impression is that there's a network of police. There's this defending their own value that they have, so that even if there's a bad apple, the police don't do their job and obey the law and make sure that the law is properly followed, but they protect the bad guys. And I think this is particularly the case when you look at like Black Lives Matter, for example.
Yes.
Violence.
No question about it. I think that there has always been in the Philadelphia Police Department, back when I was a teenager, and Rizzo was mayor, protesting in the streets of Philadelphia, the level of police corruption then has been maintained over decades. Now it's changed its form, and there have been significant attempts to try to reform the department over the years, but none of it gets to the real heart of the matter, which is police perjury. If police officers are allowed to lie about the motion to suppress, where the gun was found, whether there was a plain view sighting, whether the person made a furtive motion, which is police lingo to indicate that they should be alerted to maybe a weapon that would allow for an illegal frisk under Terry versus Ohio. These, the testimony that has allowed the expansion of police power to basically undermine Fourth Amendment rights in this city and throughout this country has gotten to almost epidemic proportions, and certainly we know that based on the litigation. And what that does is it undermines confidence in the entire system. If you allow for police officers to get on the stand and lie about the circumstances of a search and sanction that by denying the motion to suppress it, allowing the case to go forward, the system itself reinforces that misconduct over and over again. So the police officer that perjures himself or herself in a small measure on one day ends up becoming the corrupt officer, 2 or 3 years down the line, that's willing to steal money from a drug dealer, that's willing to put a case on someone because they believe that it's the right and righteous thing to do in that circumstance. That's the kind of undermining of the integrity of the system that needs to be challenged over and over again, and it needs to be rooted out. So one of the things that I'm hoping my old friend Larry Krasner does, and he seemed to indicate that he's willing to do this among a number of major significant reforms that he's brought into play, is charge police with perjury when they perjure themselves. Charge them. Make them examples. Make it clear that one of the fundamental pillars of the criminal justice system must be the honesty and integrity of those who have the power to make an arrest. And if we don't have that part of it in place, that's constantly being undermined by officers who are cutting corners and lying and perjuring themselves and staking our sense of democracy on it, because that's really what happens. People in society, people in the neighborhoods lose confidence and have lost confidence in police because they know that very easily they have the power to put a case on someone, and that case can stick and end up in a long-term period of incarceration. That's a danger to our democracy.
I would agree. I mean, we need to do a brief show ID here. So this is the Rob Call Show. We'll pause so I can paste in a bumper for the radio version of this. I'm just going to grab something real quick. And my guest for this show is defense attorney Paul Hetznecker, who I've gotten to know over the years as a defender of the rights of protesters, of victims of police abuse. And we're talking about the danger and the threat to democracy that abuses and corruption by police can bring us. Now, I just got a book yesterday that just came in, Rupture, The Crisis of Liberal Democracy. And what it's taught by Manuel Castells, and I'm going to be interviewing him in a bit, but what he talks about is how people are losing faith in democracy. They're losing faith in the system. They don't believe it in anymore. They don't believe in Congress. They don't believe in the police. And from what you're saying, they have good reason not to. How did this happen?
I think, Rob, it's a fascinating question. I think it starts with the roots of our education. We are not taught democracy as children. We're taught autocracy. Stand in line. Pledge to the flag. Don't challenge authority. Don't make waves. Don't question authority. We're taught the opposite of democracy. That's what a vibrant democracy depends upon. It's people questioning the power and the authority of an entity, whether it's a corporation or a government entity or an institution, to determine one's life, to determine the direction of a society, to determine the policies, whether social, political, or economic. And so I think at the root of it, we need to reinvigorate and identify those things that are fundamentally democratic. For example, I often tell my students, if you look around the campus and you see the associations of individuals who gather for a cause, for a purpose, who organize and direct a larger group towards a common goal, that's real democracy. That's participatory democracy in its basic form. And the way in which decision-making is made and identified is critical to, I think, having our society survive what I see to be a kind of monolithic destruction of democracy with hierarchy, with corporate structures, with not undemocratic institutions. And I think we need to reevaluate that. And I think, it's funny that, the current president is a perfect example of, the way in which people have lauded, a particular mode, aside from all his fascist tendencies. The idea that we laud a business person in that position, that's exactly what we should not have, is someone who is shown no regard for democracy at all, shown nothing but adherence to autocratic rule. And that's, I think, a lesson and a model in education. We need to re-educate our young people. We need to re-educate ourselves about what democracy looks like when it sprouts between the concretes of fascism, and you see those green sprouts coming through, and identify that's a form of democracy. That decision making, that co-op, that collective, that cooperative, that organized effort, that's a form of democracy that we need to identify and grow. And I think that's fundamental to the way in which we can establish in our society a reinvigoration and a renewal of democracy. But it has to start with educating first.
And, I smile because you say we have to reestablish what democracy looks like. And that's a chant. That was a chant that's often used. It was used during Occupy, and it's used at many protests. This is what democracy looks like. This is what democracy looks like. And it's protest. It's getting out in the streets.
It is.
I really believe, and I'm certainly not the only one saying it, that we need more and more of that now. We need protests. We need boycotts, because we have to challenge what's out there. I agree with you 100% about the authoritarian nature of our experience and our education. I love the way you're framing it in terms of healing our justice system, because it is sadly, it's ailing. It's gotten so much worse, it seems. And
it is. Go ahead. I'm sorry.
I think it's because of the politics you referred to. It's the fear, tapping into people's fear, tapping into their need for authoritarianism. And 99% of the authoritarians out there are people who want somebody to tell them what to do. There was just an article in the New York Times about how these evangelicals see Trump as King Cyrus from Isaiah 45. It looks. So what the evangelicals are basically saying is that Trump is this non-Christian king, like the non-Christian King Cyrus, who is just some kind of magical being, and they are like worshiping him as this ultimate authoritarian who's going to come in and I don't know what. I think that most evangelicals, they're looking to accelerate the process towards the rapture, when they're raptured up to heaven, leaving all us evil non-believers down behind. But I mean, it gets back to this authoritarianism. And how does that translate into the criminal justice system, authoritarianism?
I think it's a great question, Rob. And the way I would address it is from a number of different points of view. Number one, I think what you're talking about, this adherence between this religious belief and the complete absorption into authoritarian rule, is a reflection of the mass psychology of fascism, of modern fascism. And the criminal justice system, nowhere is fascism more exemplified. Nowhere is there more a powerful example of that kind of authoritarian rule than in the courtroom. So, and the courtroom offers two interesting models. It offers the monarchical power and authority of a king or a queen, as exemplified by the judge, and the participatory democracy of a jury. And it melds those two forms together. But unfortunately, because we have so few jury trials, what we have reinforced over and over again as the model of rule as exemplified in the criminal justice system, is the model of absolute rule, the absolute rule of a monarch, the absolute rule of a dictator, the absolute rule of a judge inside the courtroom. And that's not a model of democracy. That's a model of dictatorship. And that police state model, unfortunately, has become a reflection of the way in which I think we all seem to address social engineering. That somehow, in order to create a better society, a more productive society, that we need to invoke an authoritarian model to do justice, or whether it's economic justice or political or social justice. And it's a very dangerous, dangerous development. But it's a reflection of, as I said, of this mass psychology of fascism, which is really a stepchild of the Nazi era.
So what are some possible solutions? Are there any places in the United States, any systems of justice, either in the U.S. or elsewhere, where things have been are better?
Well, it's by nature, the criminal justice system in our society is adversarial, and that's not such a bad thing, and I'll explain why. Because if we do slow down this assembly line of justice, if we do step in and invoke the full panoply of constitutional and procedural rights that exist for a person charged with a crime, that exists for a person whose liberty interests are at stake, if we do invoke those, what we've seen over and over again is real powerful challenges to authority and police power. So, for example, as I indicated, we've had two major lawsuits in the course of the last decade, one in New York City, one here in Philadelphia, and I'm sure there are others, which challenged the system of stop and frisk. And when I say stop and frisk is simply a reflection of the words used in the decision in 1968 in Terry versus Ohio. But basically, the implementation, the practical impact of stopping and frisking anyone, not within the boundaries and parameters of what the Constitution requires, but simply within the full unfettered discretion of the police officer, essentially is where the police state meets our democracy. It's where the intersection of our liberty interests, protected by the First Amendment, are impacted by the police power of the state to take away those liberty interests. And so those lawsuits exemplify a challenge, a powerful challenge to the practices conducted by both of these large urban police departments, and said, hey, wait a minute, this is an undermining. This is not a constitutional mandate that you're fulfilling. This is a constitutional undermining. You are undermining the protections afforded under the Fourth Amendment by conducting, the mass scale stops and frisks and searches, full-blown searches of individuals that fit a profile. And a lot of it was race-based. A lot of it is racist, institutionalized racist policing. And those challenges were powerful. Those are examples of ways in which a challenge to the structure within the criminal justice system, even though it's in a civil rights context, can be successful and can alter the perception of the public about the power that the police have and the powers that should be limited by our democracy. And so those are examples. And another example within the criminal justice system would be that's in the beginning of the system, in this assembly line. And the back end of the system is sentencing. So alternatives to incarceration, diversion at the front end when people do get arrested, diverting these individuals to programs, drug treatment programs, alternative resolution programs, alternative dispute resolution, a way in which there's an attempt to try to reconcile within this adversarial process. So, community-based lawyering that coincides with the notion that you reach out in the community and say, this line between defendants and complainants, between victims and those charged, is not a real line. It's essentially a community in turmoil, a community that's suffering, and all the ills within our society, whether they're political, economic, or social, get dumped on the criminal justice system, and it's for us to resolve them. Well, we can't resolve them. We certainly don't resolve them by locking whole generations of young people up for lengthy periods of time. And so I think the reexamination of how both not to charge or to divert, how not to police, to enforce community-based policing instead of this notion of occupying a neighborhood like it's a military zone, and on the back end in sentencing to find alternatives to incarceration. Those are good examples, again, of reforms. These aren't radical changes, but they're reforms, as I talked about in the beginning of our interview, that reflect a movement towards a more just system and away from this assembly line of injustice. And it's not going to be achieved overnight. It's not going to be achieved with one great swath of programs. It has to be achieved by an enlightened sense of how important the criminal justice system is in this mosaic of our democracy.
Now, you've just described two solutions that are based on